Good evening. I am Dr. Bob Uzzle, instructor in political science at Navarro College. Hope everybody has had a enjoyable Easter in spite of the unusual set of circumstances we have right now. This is a lecture related to order and civil rights, which is or rather equality and civil rights for my class in federal government. Civil rights and civil liberties are closely related but are not identical. And we're going to talk today about the importance of civil rights. Civil rights are defined as powers and privileges granted or guaranteed to individuals protected from arbitrary removal at the hands of government individuals. We understand the idea of inalienable rights, natural rights, rights that you have as a result of being a human being. No government should have to give them to you. No government should be able to take them away from you. Now, unfortunately, too often in the real world, it doesn't work that way. But that's the way it's supposed to work. There's a distinction made between invidious discrimination, which is discrimination against persons or groups that works to their harm, is based on animosity. Then there's benign discrimination, causes no harm because it's grounded in reason. For example, in the United States, we discriminate by only allowing people with a driver's license to drive a car. Is that discriminatory? Well, yes, it is in a way, but it's benign. People have to meet certain requirements. And banning African American adults from driving would be invidious discrimination, because its only possible justification would be to treat this group unfairly and with animus. So you have, whether it's to drive a car or do brain surgery, you have to meet certain requirements. You've got to pass certain tests. You've got to meet certain standards. That has nothing to do with race or gender. Equality of opportunity is the idea that each person is guaranteed the same chance to succeed in life. Most people, you ask them, they believe in that. Yeah, I believe that. That's fine. Equality of result, the concept that society must ensure people are equal, that governments must design policies to redistribute wealth and status so that economic and social equality is actually achieved. Most people would agree with the idea you need to have a floor on income, to the point where income shouldn't fall below a particular level. Fewer people would agree with the idea of a ceiling on income. You could only make so much and no more. And the idea that everybody has the same, even though one person works hard and the other person hardly works. Well, most people would agree that if you earn it, you should have it. If you're lazy and not, if there's reasons for having certain things and not having certain things. The Civil War amendments were very significant, have had a tremendous impact on our society. 13th and 14th and 15th Amendments. 13th Amendment was passed in 1865. It abolished slavery. Some of you may have seen the movie Lincoln, a very good movie. Describes the last 4 months in the life of Abraham Lincoln when he was lobbying Congress to pass the 13th Amendment. to forever end slavery. And in order for an amendment to become part of the Constitution, it has to be passed by 2/3 of both houses of Congress, and it has to be ratified by 3/4 of the states. Let's say 3/4 of the states ratify, 1/4 doesn't. Well, the 1/4 that doesn't is still bound by the amendment. And the interesting bit of trivia, it went into effect in 1865, the 13th Amendment did, but not every state got on board immediately. I understand New Jersey wasn't part of the original crowd. They ratified it in 1866, 1 year later. Little by little, they came around. Kentucky ratified it in 1976. If you think that's bad. Mississippi officially ratified the 13th Amendment February the 7th, 2013, just 7 years ago. That took a long time. And to be fair to Mississippi, let me tell you what they did. That wasn't their first effort to ratify it. No. They tried to ratify it earlier, 1995. But they failed to submit the proper paperwork to the National Archive. There was a professor from India who taught at a medical school in Mississippi who saw the movie Lincoln. And he went to the website of the U.S. Constitution to see when the different states ratified. And he learned because the proper documentation never been sent to the National Archive, Mississippi's ratification was not official. He let one of his colleagues know. This colleague was a native of Mississippi. What he did, he found out what paperwork was needed to go to the National Archives. They submitted the proper paperwork February 7th, 2013. Mississippi's officially on board, no more slavery. Obviously, slavery had not been legal in Mississippi since 1865. Better late than never, but that sure did take a long time. The 14th Amendment, 1868, gave former slaves citizenships. But it's very interesting. There was more litigation over the due process and equal protection clauses of the 14th Amendment than all of the rest of the Constitution combined. For example, in the 1870s, there was the slaughterhouse cases that was decided, and these cases had nothing to do with African Americans. It had to do with monopolies and butcher shops. And so a corporation, for the first time, was considered a person before the law. Then the 15th Amendment gave African Americans the right to vote. Again, it didn't apply to everybody. Only African American males. That's 1870. Females wouldn't get it nationwide until 50 years later, in 1920, with the adoption of the 19th Amendment. And so there was a lot of efforts to circumvent the 15th Amendment. And that's still going on today some places. Black codes were legislation enacted by former slave states to restrict freedom for blacks. It was called Code Noir in Louisiana. Noire is the French word for black. A poll tax was a tax of $1 or $2 on every citizen who wished to vote. First instituted in Georgia in 1877. Although it was no burden on most white citizens, it effectively disenfranchised blacks. Keep in mind, $1 or $2 was harder to come by back then. It would buy a lot more than it will today. And separate but equal doctrine, the concept providing separate but equivalent facilities for blacks and whites, satisfies the Equal Protection Clause of the 14th Amendment. At one time, that was the law of the land. In fact, for a period of 58 years, 1896 to 1954. There was an infamous Supreme Court decision in 1896, Plessy versus Ferguson. Homer Adolph Plessy was an octoroon. You know what that is? He was 7/8 white, 1/8 black. You've seen a picture of him. He could certainly go anywhere he wanted to without being bothered because he could easily pass for a white man. But on this occasion, he chose not to pass. He let the railroad company know his ethnic background, and he told them he was going to sit in the white car. They said, no, you can't. Well, but he had more white than black blood, but that was beside the point. The infamous one-drop rule. Any trace of African ancestry, you're black. Well, this case reached the U.S. Supreme Court. By an 8-1 decision, the court struck down, or rather, no, they didn't strike down anything. Pardon me. They upheld Louisiana's separate coach law. This was in New Orleans where all this took place. And Plessy was told he had to sit in the black car because of his any measurable African blood. And that was the law of the land for the next 58 years. It was an 8-1 decision. Justice John Marshall Harlan I was the lone dissenter. He was from Kentucky, a former slaveholder, but he had a very interesting insight, and he upheld the idea of equality before the law, though he had some of the same racist views of many of his contemporaries. I refer to him as John Marshall Harlan I because he had a grandson, John Marshall Harlan II, who later served on the Supreme Court. He was pretty conservative and was noted as a dissenter during the golden age of liberalism on the court, the period led by Chief Justice Earl Warren. And but in 1954, Plessy versus Ferguson was overturned by Brown versus Board of Education of Topeka. Desegregation is the ending of authorized segregation by race. There's two different kinds of segregation: de jure, government-imposed segregation; de facto segregation, that is not the result of government action. And people choose to live certain places, for example. And there's an image here. Anger erupts in Little Rock. 1957, the Little Rock, Arkansas School Board attempted to implement court-ordered desegregation. 9 black teenagers were to be admitted to Little Rock Central High School. Governor Orville Faubus ordered the National Guard to bar their attendance. A mob blocked a subsequent attempt by the students. Finally, President Dwight D. Eisenhower ordered federal troops to escort the students to high school. And it's interesting, the year before, there had been a similar confrontation in Mansfield, Texas, south of Fort Worth. Eisenhower did nothing. Then in 57, he intervenes in Little Rock. Historians are pretty well agreed why the difference between one year and another. In 1956, Ike was up for re-election. 1957, he had already been re-elected. He couldn't run for a third term. So he could stand for what was right without having to worry about how it was going to affect him at the polls. And we see a famous picture of Hazel Bryan Massery angrily taunted her. This was a white girl, 15-year-old black girl, Elizabeth Eckford, screaming expletives at her. And that was a very interesting ordeal in 1957. There's a book came out about Elizabeth and Hazel, 2 women of Little Rock. In 1997, they had the 40th anniversary of desegregation. And it shows the two women arm in arms as friends because Hazel had apologized. Elizabeth had accepted her apology. They appeared on shows together and traveled around together some, but unfortunately, the friendship didn't work out. There were some people accused Hazel of having ulterior motives, and that I don't know. It was. It's just very unfortunate that eventually the friendship fell apart. And but the there's a book written about those two women. There's been a lot of different legislative efforts over the years to deal with civil rights, and the decades of the 50s and the 60s were very important as far as major changes in the United States. Many things are concerned, including race relations. It was in 1954. We've already talked about the Brown decision a little bit, but it was not implemented immediately. There was massive resistance throughout the country, and many school districts didn't integrate until the 1960s, or maybe some even in the 70s. They found stalling techniques. 1955 Brown 2 decision called for desegregation with all deliberate speed. Some interpreted the term all deliberate speed as giving them permission to wait 100 years, which was not, it wasn't meant that way at all. And in 1955, in the Mississippi Delta, a young man from Chicago by the name of Emmett Till got off of an Illinois Central train. At the time, Chicago had more Mississippi-born blacks than any place in the country, except for Mississippi itself. And Emmett Till, his cousins had visited him in Chicago. He wanted to visit them in the Mississippi Delta. Well, his mother and grandmother, who were from Mississippi, they coached him about the ways of the Delta, very different than Chicago. And he was dared by some cousins to go into this store and flirt with this white woman behind the counter. Nobody knows for sure what happened. Well, I guess she's Carolyn Bryant Donham is still living. She knows what happened, but as far as I know, she never has told the whole story. But there's different accounts on what took place. Did he whistle at her? Did he grab her by the arm? Did he ask her for a date? Well, whatever happened, when her husband got back from Texas, he was very angry. He and his half brother went and murdered Emmett Till. And these two white men were found not guilty by an all-white, all-male jury who took a little over an hour to deliberate. They took a break and drank Coca-Cola to give the impression they were really deliberating. And initially, these guys were embraced by the white community, but then it didn't go so well for them. Now, they ran a series, the Bryant and Donham, Bryant and Milam families ran a series of a chain of grocery stores in the Mississippi Delta. Most of their clientele was African Americans. Well, there's a economic weapon anybody can use. It's called a boycott. And the people wouldn't buy from them. Can you blame them for that? Within 18 months, they were out of business. And among the white people of the Delta, well, murderers don't make very lovely neighbors. So it wasn't for too long before they were ostracized, and They moved to East Texas for a while, eventually moved back to the Delta. Roy Bryant had been willing to kill to protect the honor of Carolyn, his wife, who was described by a French newspaper as a crossroads Marilyn Monroe. Well, in 1978, she divorced him and remarried. He also remarried. Well, today, J.W. Milam and Roy Bryant are dead, as is Juanita Milam, the wife of J.W. Milam. Carolyn is still living, and again, there's different accounts of what she's said or refused to say. But that was in the Mississippi Delta. And it got the whole world focused on Mississippi and on the racism of America. Right next door in Alabama, there was a woman whom I had the pleasure of meeting in Dallas in 1985. Her name was Rosa Parks. Rosa Parks was already tired of sitting on the back of the bus. And you can't say that the murder of Emmett Till is what did cause the Montgomery bus boycott. But it was certainly a catalyst that helped speed it up. And it read an interesting story about it took over a year for the boycott to succeed. And there was one black woman who worked as a maid for a white family in Montgomery. She didn't have a whole lot of education, but she knew a little bit of psychology. Her boss lady said, "You're not supporting that boycott, are you?" She said, "No, ma'am. I'm just staying away from the buses till all the trouble's over." She walked to and from work, held her head high, and kept her job. And in 57 was the year of the desegregation crisis. There was a movie about that, the Ernest Green story. Ernest Green was the first black graduate of Central High School. In the late 1970s, he served as Undersecretary of Labor in the administration of President Jimmy Carter. And at the time when he was in that position, former Governor Orville Faubus, who had tried to keep him out of the school, was eking out a living as a bank teller to supplement his meager governor's pension. I think Faubus died about 1994, and he was described as the second most famous governor of Arkansas, second only to Bill Clinton. And I had the pleasure in 1994, when I was at a meeting in Little Rock, of meeting Daisy Bates, who was the publisher of the Arkansas State Press. And I got an autograph of her autograph on my copy of her book, The Long Shadow of Little Rock. And but the 1964, they passed the Civil Rights Act, and that was following some of the developments in Mississippi known as the Mississippi Freedom Summer. A year later, following the Selma and Montgomery March, they passed the Voting Rights Act, and the movie Selma deals with a lot of that. And much violence took place, and much sacrifice was made to get equality and freedom for all. Dr. Martin Luther King gave his famous "I Have a Dream" speech, August 28th, 1963. And he at the time, John F. Kennedy was president, and he'd come out for civil rights. But 3 months later, he was assassinated, and the Civil Rights Bill was still bogged up in committee. His first speech to a joint session of Congress, the new President Lyndon Baines Johnson declared that if you want to show honor to the memory of President Kennedy, can do no better than passing the Civil Rights Act with all deliberate speed. He eventually, according to the movie Selma, he was reluctant to act, and not everybody was pleased with the way LBJ is depicted, but one of the memorable scenes is a telephone conversation in which Dr. King says to him, I'm a preacher from Atlanta. You're the head of the most powerful nation on earth, who a few months ago was reelected with the biggest landslide in history, and every second you're dismantling your legacy. Well, Johnson, shortly after that, spoke before a joint session of Congress, presented a civil rights bill, or voting rights bill, rather, and said, we shall overcome. After the bill finally passed, one of his staff was in his office. He found him to be rather depressed and despondent. Mr. President, you ought to be elated. You got what you wanted. After the ceremony, the hoopla was over. Bill, I think we've just lost the South. We've just handed the South over to the Republican Party. His words proved true because the solid South was solidly Democratic. When I was growing up in Texas, Republicans were few and far between. Generally, whoever won the Democratic primary, they won the general election. That ain't true anymore. And the shift from blue to red didn't happen overnight, but it did happen. And the 1964, of course, Texas was won by native son Lyndon Johnson, who won by one of the biggest landslides in history. But at the same time, several southern states, former Confederate states, that had never voted Republican before, voted for Barry Goldwater. And Goldwater had said, extremism in defense of liberty is not a vice. Moderation in defense of freedom is not a virtue. Goldwater denied being a racist. He said he believed it was best if black and white children would attend the same schools, but he felt like that decision should be made by the local school board rather than by the federal government. And so it was a very small organization. I've seen a picture of their headquarters, Negroes for Goldwater, which he didn't have a whole lot of African American support, I can tell you that. But the many acts were passed, and the 24th Amendment, ratified in 1964, banned poll taxes in primary and general elections for national office. The Voting Rights Act of 1965 empowered the Attorney General to send voter registration supervisors to areas in which fewer than half the eligible minority voters have been registered. The Fair Housing Act of 1968 banned the discrimination in the rental and sale of most housing. George Bush, future president of the United States, I'm talking about the older George Bush, George Herbert Walker Bush. He was a congressman from Houston at the time. He voted for that voting rights, rather for the this Open Housing Act of 1968, and faced a very hostile audience in a room in Houston. But he had always worked to make the Republican Party in Texas inclusive. And he said, truthfully, African American servicemen were fighting and sacrificing in Vietnam. Many were coming home and could not find suitable housing. And that was certainly very, very wrong. Our textbook doesn't say much about this, but In my opinion, one of the most important decisions of the Supreme Court came on June the 12th, 1967, the case of Loving versus Virginia, in which a white man named Richard Loving in 1958 had married a woman named Mildred Jeter, who was part black and part Native American. And Richard Loving and Mildred were not allowed to settle in Caroline County, Virginia. They moved to Washington, D.C., where they got married there. But they were not allowed to stay in their home state. And while the debate was going on for the 1964 Civil Rights Act, Mildred wrote Bobby Kennedy a letter, who was Attorney General at the time, got his attention. And he ended up referring the case to Bernie Cohen of the American Civil Liberties Union, who was assisted by Phil Hirschkopf, another civil rights lawyer. And they realized this was a very important case. And Bernie later described this very simple letter that he got from Mildred Loving, which got him involved in a not so simple case. And there have been two movies made about this. The most recent one, Loving, came out a few years ago. Joel Edgerton plays the part of Richard, and Ruth Negga plays the part of Mildred. Ruth is from Ethiopia. Joel is from Australia. Very good movie. But neither Richard nor Mildred ever finished high school. And they were pretty simple people, country people. Richard he worked with his hands, a bricklayer, mechanic, does stuff like that. His favorite hobby was race cars. And he couldn't understand why Bernie Cohen could not just go back to Judge Bazile, who originally heard the case, get him to rescind the decision, and they could move back. Well, it wasn't that simple. They had to go before the local court again. They had to go through the appellate level court, the state Supreme Court, knowing they would lose at every step of it. But Bernie Cohen assured them, no, this reaches the U.S. Supreme Court, this law will not stand. This law is unconstitutional. June 12, 1967, U.S. Supreme Court in Loving versus Virginia declared all state anti-miscegenation laws to be unconstitutional. And they were allowed to move back to Virginia. Richard built Mildred a house. Sadly, in 1975, they were hit by a drunk driver. Richard was killed instantly, and Mildred lost an eye. She never remarried. She lived in that house that Richard had built for her, and she passed away in 2008. I had several telephone conversations with her, and many of us consider her the equal of Rosa Parks as far as civil rights is concerned, though she never claimed that for herself. The other issues related to civil rights includes women's rights. And the idea of protectionism, women must be protected from life's cruelties. Till the 1970s, the basis for laws affected women's civil rights. The 19th Amendment, adopted in 1920, ensures women have the right to vote. Women's suffrage was a hot button issue at one time. A lot of people were against it. And there were quite a few women who were against women's suffrage, if you can believe that now. Equal Rights Amendment, ERA, the failed constitutional amendment introduced by the National Women's Party in 1923, declaring that equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. It was passed by Congress in 1972. It was supported by Presidents Richard Nixon, Gerald Ford, and Jimmy Carter, but it was not supported by Ronald Reagan. And in 1980, the Republicans dropped their support for ERA. In January 22nd, 1973, when Roe v. Wade legalized abortion, that undercut much of support for the ERA. And in the 70s, I can remember seeing a lot of letters to the editor. People opposed, well, pros and cons, people on both sides of the question, but the cons really stood out. And not everybody opposed to the ERA were men. There were women who wrote against it as well. And finally, in 1982, which was the midterm of Reagan's second term in the White House, ERA died. There's been some efforts to revive it, but thus far it has not been successful. And some said it would make it impossible to have a mother and daughter lunch or father and son breakfast. It wouldn't have gone that far. And but there's many our textbook also deals with shows how the quest for equality, for gay rights, it moves from a fringe movement to mainstream idea. June 27th, 1969, that Friday evening, plainclothes New York City police raided a gay bar in Greenwich Village known as Stonewall Inn. The police justified the raid because they suspected that the Stonewall lacked a proper liquor license. And this has been declared as the beginning of the gay rights movement. A gay faction within the Democratic Party is called Stonewall Democrats. And by the way, there's a much smaller faction within the Republican Party known as the Log Cabin Republicans. And it's over time, you know, what nobody supported, so many public figures now support. And the June 26th was an important day on the calendar of the gay rights movement 3 different times. On June 26, 2003, Lawrence versus Texas, the Texas sodomy law was declared unconstitutional. Then on June 26, 2013, exactly 10 years later, the Supreme Court struck down part of the Federal Defense of Marriage Act, DOMA, in the case of United States versus Windsor. Then exactly 2 years later, June 26, 2015, in Obergefell versus Hodges, same-sex marriage was legalized nationwide. And in the meantime, you know, when Bill Clinton had run for president in 1992, he pledged to lift the ban on gays in the military. And when he tried to do so, he ran into a lot of trouble and a lot of opposition. Finally, they reached a compromise. Don't ask, don't tell. They would no longer ask the question about sexuality. As long as one didn't let it out, they would be okay. Well, don't ask, don't tell existed from 1993 until about 2011 or 12, in which the Obama administration got rid of it, and gays and lesbians are now able to serve openly in the military. Many had been in there before without obviously lying in order to gain admission. Native Americans have faced many problems over the years, and they have a very interesting history. They were here before anybody else was. And um, General Philip Sheridan is quoted as saying, when an Indian leader tried to surrender to him and spoke to him in broken English, he said, "Me, good Indian." The general's response was, "The only good Indian is a dead Indian." And Richard Pratt, the director of the Carlisle Institute in Pennsylvania, had a different philosophy. He did not support physical genocide, rather cultural genocide. Kill the Indian, he said, and save the man. In other words, make him cut his hair, make him adopt the Christian religion, make him wear European style clothes, teach him to farm, teach him to do manual skills. Under no circumstances should he be allowed to wear Indian style clothes or participate in any traditional ceremonies. The later generations became more uh, open to the idea of accepting Native American culture for its own benefit. In 1970, a book was published by D. Brown called "Bury My Heart at Wounded Knee: Indian History of the American West," and it was on a lot of college reading lists back in that decade. But Wounded Knee, a place in South Dakota, December 1929, the Army came in and slaughtered Chief Bigfoot and many of his followers. The American Indian Movement, on February 17, 1973, they seized 11 hostages at Wounded Knee, South Dakota, the site of the massacre. They remained there, occasionally exchanging gunfire with federal marshals for 71 days until the government agreed to examine the treaty rights of the Oglala Sioux. That was in February 1973. February 27th is very interesting to me. It was exactly 20 years to the date that the first installment of the Sinful Messiah, a series of news articles about the religious sect outside of Waco called the Branch Davidians. It was published in the Waco Tribune Herald. The next day, the compound was raided by the Bureau of Alcohol, Tobacco, and Firearms, and another standoff began, although the two situations are very different. And the 1946, Congress enacted legislation establishing Indian Claims Commission to compensate Native Americans for land that had been taken from them. In the 1970s, Native American Rights Fund and other groups used that legislation to win important victories in the courts. Tribes won the return of lands in the Midwest and the states of Oklahoma, New Mexico, and Washington. In 1980, the Supreme Court ordered the national government to pay the Sioux $117 million, plus interest, for the Black Hills of South Dakota, which had been stolen from them a century before. And there have been other issues related to civil rights of various immigrant groups, and immigration remains a hot potato issue today, no question about that. The civil rights of language minorities, with additionally large implications for Hispanics, who also were addressed in 1975 adjustment to the Civil Rights Act, signed into law by Republican President Gerald Ford. Those revisions and subsequent changes in other years required certain jurisdictions to provide other materials, including registration information, ballot instructions and ballots themselves. With Hispanics are now the largest minority group, and the population is increasing quite rapidly. So we see a lot of things are changing, and I know in the state of Texas, used to be Democrat, now it's Republican. Most everybody, though, agrees that with a growing Latino population, should be beneficial to the Democrats and make Democrats competitive in Texas again. Most everybody agrees that that will happen. Nobody knows when. Struggle for racial equality, of course, still exists. There's also been efforts to deal with problems of accommodation for people with disabilities. It was in 1990 that President George Herbert Walker Bush signed into law ADA, Americans with Disabilities Act. So battles still go on as far as voting rights. Now you have to have a picture ID, and some consider that to be problematic. So the battles over civil rights, a lot of progress has been made, but we still have a ways to go. Affirmative action are programs that are designed to give people, such as minorities and women, previously disadvantaged groups, certain advantages. And obviously white males are the ones who are at a disadvantage when that happens. In June 1978, there was a case that reached the U.S. Supreme Court related to reverse discrimination. Alan Bakke was a white man. He was a Vietnam veteran. He was an engineer by profession. He wanted to be a doctor. So he enrolled in he applied to the medical school at the University of California at Davis. He was turned down. They had quotas in place, affirmative action. And certain slots were set aside for minority applicants. There were some members of minority groups who scored lower on the entrance exam than Bakke. They got in, but he didn't. He sued. He reached the Supreme Court and he won. He was admitted. By the way, the Supreme Court in this case did not strike down affirmative action. It didn't say you can't use race as a criteria in affirmative action programs. It just can't be the only criteria. And he said that they said that the affirmative action system at the University of California at Davis was too rigid. They ordered Bakke admitted. He 3 or 4 years later, he graduated. He eventually returned to his home state of Minnesota, where he practiced as an anesthesiologist. I think he's still living. He has never been willing to comment on the case. So anyway, this just gives you an overview of some of the more important cases and developments related to equality and civil rights. Have a good evening.